This hearing will come to order. I want to thank Inspector General Horowitz and his team for being here. I know in the Judiciary Committee hearing you had everybody raise their hands, so if you maybe raise your hands, identify yourselves, all the people who do this excellent work. Appreciate that. But I want to thank you for all your hard work and efforts preparing the report that is the main subject of our hearing today. The bipartisan praise you have already received for your efforts is well deserved, and I share those sentiments. The release of this report is an important step in providing the public answers to many of the questions that have festered for far too long. But as thorough as this report is, its scope is also narrow, and many important questions remain unanswered. Much attention has been paid to the report's conclusion that the Crossfire Hurricane investigation did have adequate predicate, but that inaccuracies and omissions in the FISA application and renewals call into question the integrity of that process. Yesterday's order by the presiding judge of the Foreign Intelligence Surveillance Court is a dramatic rebuke and underscores how serious the FISA warrant abuses are. But I would argue that, based on what the report reveals about early knowledge within the FBI, we should be asking a more fundamental question. At what point should the investigation into possible collusion between Russia and the Trump campaign have been shut down? Although the IG concluded the investigation was properly initiated, the consensual monitoring of Trump campaign officials conducted in the first 6 weeks did not result in, quote, the collection of any inculpatory information. But rather than shut it down or use the least intrusive methods, the FBI ramped it up. Confidential human sources became FISA wiretaps. Top FBI officials argued, by the way, disagreeing with the CIA on this, for inclusion of the unverified and salacious Steele dossier into the body of the Obama administration's intelligence community assessment. And finally, the FBI investigation ballooned into a special counsel investigation. As a result, the Trump administration was tormented for over 2 years by an aggressive investigation and media speculation, all based on a false narrative, and our nation has become even more divided. For anyone willing to take the time to read the report is a devastating account of investigative and prosecutorial negligence, misconduct, and abuse of the FISA court process by FBI, and Department of Justice officials. The most disturbing revelations of the IG investigation include reports of doctoring and using an email to mislead the FISA court, ignoring the fact that exculpatory evidence was obtained during surreptitious recordings of investigation targets, deciding not to provide a defensive briefing to the Trump campaign, planting an FBI investigator in an intelligence briefing for candidate Trump under false pretenses, and withholding known and significant credibility problems related to the Steele dossier. With these abuses in mind, and in light of what became known early in the investigation, I strongly believe the Crossfire Hurricane should have been shut down within the first few months of 2017. Had the public known what the FBI knew at the time, it's hard to imagine public support for continuing the investigation, much less the appointment of a special counsel 4 months later. Investigations into Russian hacking, Paul Manafort and Michael Cohen should have continued using normal FBI and Department of Justice procedures. But with a sufficiently informed public and an FBI and Department of Justice that rigorously followed their own procedures, this national political nightmare could have been avoided. Which raises the question, why wasn't the public properly informed? Some of the reasons are now obvious, some are speculative. What is obvious is that certain FBI and Department of Justice officials were not truthful or scrupulously accurate in their filings. Also, as this committee's majority staff report on leaks in the first 4 months of the Trump administration shows, an unprecedented number of leaks, 125 in the first 126 days of the administration, helped fuel the false narrative of Trump campaign collusion with Russia. The media was either duped or complicit in using those leaks to perpetuate this false narrative. The role of other Obama administration officials and members of the intelligence community is murky and unknown, but legitimate suspicions and questions remain and must be answered. For example, Who initiated the contacts between Joseph Mifsud, Alexander Downer, Stefan Helper, and Azra Turk with George Papadopoulos? Was the January 6th intelligence briefing given to President-elect Trump by James Comey, John Brennan, and James Clapper orchestrated to provide a justification for the news publication of the Steele dossier? The fact that the involvement of others outside the FBI and Justice Department remains murky and unknown after an 18-month-long Inspector General investigation is not criticism of his work, but speaks to the statutory limitations of inspectors general that should be evaluated and reassessed for reform. Another question that needs to be asked is, who will be held accountable? During his investigation of the FBI's handling of the Clinton email scandal, the Inspector General uncovered a treasure trove of unvarnished evidence of bias in the form of texts between FBI officials Peter Strzok, Lisa Page, and others. Were it not for the discovery of those texts, would we even be here today reviewing an IFG investigation of these stunning abuses of prosecutorial power? I have my doubts. The officials involved in this scandal had plenty of time to rehearse their carefully crafted answers to the IG's questions or to use time as an excuse for their lack of recall. For example, on significant issues described in the report, Andrew McCabe told IG investigators 26 times that he did not recall. Some of those involved are even claiming vindication as a result of the IG report. I appreciate Mr. Horowitz's testimony last week in which he stated about this report, quote, "It doesn't vindicate anybody at the FBI who touched this, including the leadership." Finally, I would argue that the process for investigating and adjudicating alleged crimes within the political realm is completely backward. Congressional oversight and therefore public awareness end up being the last step in the process instead of the first. Once a criminal or special counsel investigation begins, those investigations become the primary excuse for withholding information and documents from congressional oversight and public disclosure. In order to avoid a repeat of unnecessary special counsels or improper investigations of political scandals, I would suggest that Congress should increase its demands for obtaining documentary evidence concurrently with criminal investigations if necessary, and hold hearings early in the process. This will result in more timely transparency while preserving an adversarial process to provide political balance and fairness. If possible criminal acts are found during congressional oversight, they can be referred to the Justice Department for further investigation. If conflicts of interest that prevent a fair adjudication by the Justice Department, then a special counsel can be appointed, but only as a last resort, not a first. I'm sure we will spend most of today's hearing discussing the Crossfire Hurricane investigation and the Inspector General's report on it. But I do hope we can spend some time discussing some of the other issues I've just raised. Regardless, this committee's oversight on the events involved with and surrounding the FBI mid-year exam and Crossfire Hurricane investigations will continue until I am satisfied that all important and relevant questions are being answered. Senator Peters.
Thank you, Mr. Chairman. Mr. Horowitz, thank you for being here today and for your testimony. Inspectors General play a vital role in conducting oversight, offering independent assessments of how programs are working and holding agencies accountable when errors are made. The Justice Department Inspector General's Office conducted a thorough 19-month investigation, interviewing more than 100 witnesses and analyzed more than 1 million pages of materials to complete the report that we're going to be discussing here today. This report found unequivocally that the FBI investigation into coordination between individuals affiliated with President Trump's campaign and the Russian government had a proper legal and factual basis and found no evidence that the investigation was affected by political bias. Politically motivated investigations are a betrayal of our bedrock democratic principles, and this institution should speak with one voice to say that it will not tolerate them no matter who is in power. In this case, the report found that the investigation was rooted in identifying any federal criminal activity or threats to American national security. The Inspector General verified that politics played no role whatsoever in opening this investigation. Importantly, the report did find that there are areas that do need improvement, including the process used to obtain FISA warrants. Identifying these areas for improvement is a key part of an Inspector General's role, and I applaud the Inspector General's robust and thorough work to shine light on the FBI as well as the Justice Department's shortcomings. It is this independence and commitment to the rule of law that sets our institutions apart. FBI Director Wray has received this report and agreed with its core conclusion that political bias played no role in opening the investigation. Director Wray also accepted the Inspector General's findings that errors occurred in the FISA process and ordered more than 40 corrective actions to improve and reform this important process. I hope that today's hearing provides this committee with the opportunity to carefully examine this report's recommendations and determine whether there are areas that we can help strengthen as well. However, the most important fact that we should take away from this report and this hearing is that Russia, a foreign adversary, engaged in a sweeping and systematic effort to interfere in the 2016 presidential election, and that the FBI was right in investigating those who may have been involved. The Russian government's effort was an attack on our democracy and on our national security, and it's happening again. The Russian government is intent on sowing distrust, spreading misinformation, and undermining democracy, and they will pursue these efforts at all costs. Members of both parties must come together to pass legislation strengthening election security and ensure that no foreign adversary can meddle in our elections again. I had the opportunity to work with Chairman Johnson and Senator Langford on bipartisan legislation to strengthen cybersecurity standards for our voting machines, and I hope that we can continue working together to identify these kinds of common sense steps that will protect the very heart of our democracy. Finally, Inspector General Horowitz, I'd like to thank you and your team for your independence, your integrity, and your hard work in completing this report, and I look forward to your testimony.
Thank you, Senator Peters. It is the tradition of this committee to swear in witnesses, so if you please stand and raise your right hand. Do you swear that the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. Mr. Michael Horowitz has served as the Inspector General of the Department of Justice since April 16, 2012. He also chairs the Council of Inspectors General on Integrity and Efficiency. It's a lot easier to say SIGI. Prior to joining the Inspector General's office, Mr. Horowitz worked in private practice and before then as a federal prosecutor in the Department of Justice. Mr. Horowitz.
Thank you, Mr. Chairman, Ranking Member Peters, members of the committee. Thank you for inviting me to testify today. The report that my office released last week is the product of a comprehensive review that examined over 1 million documents and conducted over 170 interviews involving more than 100 witnesses, all of which is documented in our 417-page report. It also includes a 19-page executive summary, which, if folks don't have the time to read 400-plus pages, I would certainly encourage people to read the 19-page executive summary. I want to commend also the tireless efforts of the team that did this. They worked rigorously through long hours to complete this review. The investigation that's the subject of our report, the Crossfire Hurricane investigation, was opened in July 2016, days after the FBI received reporting from a friendly foreign government stating that in May 2016, Trump campaign foreign policy advisor George Stephanopoulos, quote, suggested the Trump team had received some kind of a suggestion, close quote, from Russia that it could assist in the election process with the anonymous release of information that would be damaging to candidate Clinton and then President Obama. We determined that the decision to open Crossfire Hurricane was made by the FBI's then Counterintelligence Division Assistant Director, Bill Priestap, and that this decision reflected a consensus reached after multiple days of discussions and meetings among senior FBI officials. We reviewed Department and FBI policies and concluded that Assistant Director Priestap's exercise of discretion in opening the investigation was in compliance with those policies. We also reviewed his emails, texts, and other documents, and we didn't find documentary or testimonial evidence that political bias or improper motivation influenced his decision. While the information in the FBI's possession at the time was limited, in light of the low threshold established by Department and FBI predication policy, We found that Crossfire Hurricane was opened for an authorized purpose and with sufficient factual predication. This decision to open Crossfire Hurricane was, under Department and FBI policy, a discretionary judgment left to the FBI. There was no requirement that department officials be consulted or even notified prior to the FBI making that decision. Consistent with this policy, the FBI advised the department's National Security Division of the investigation days after it had been initiated. As we detail in our report, advance department notice and approval is required in other circumstances where investigative activity could substantially impact certain civil liberties, allowing department officials to consider the potential constitutional and prudential implications in advance of these activities. We concluded that similar advance notice should be required in circumstances such as those present here. Shortly after the FBI opened the Crossfire Hurricane investigation, the FBI monitored meetings and recorded several conversations between FBI confidential human sources, or CHSs, and individuals affiliated with the Trump campaign, including a high-level campaign official who was not a subject of the investigation. We found that the CHS operations received the necessary approvals under FBI policy, that an assistant director knew about and approved of each operation, even in circumstances where a first-level FBI supervisor could have approved it, and that the operations were permitted under department and FBI policy because their use was not for the sole purpose of monitoring activities protected by the First Amendment or the lawful exercise of other rights secured by the Constitution or laws of the United States. We did not find documentary or testimonial evidence that political bias or improper motivation influenced the decision to conduct these operations. Additionally, we found no evidence that the FBI attempted to place CHSs within the Trump campaign or report on the Trump campaign or to recruit members of the Trump campaign to become FBI CHSs. However, we're concerned that under applicable FBI and department policy, it would have been sufficient for a first-line FBI supervisor to authorize the sensitive domestic CHS operations undertaken in Crossfire Hurricane, and that there is no department or FBI policy requiring the FBI to notify department officials of a decision to task CHSs to record conversations with members of a political presidential campaign. We concluded that current department and FBI policies are not sufficient to ensure appropriate oversight and accountability of such operations. One investigative tool for which department and FBI policy expressly requires advance approval by a senior department official is the seeking of a court order under FISA. When the Crossfire Hurricane team first proposed seeking a FISA order targeting Carter Page in mid-August 2016, FBI attorneys assisting the investigation considered it a close call, and a FISA order was not sought at that time. However, in September 2016, immediately after the Crossfire Hurricane team received reporting from Christopher Steele containing allegations regarding Page's alleged activities with certain Russian officials, FBI attorneys advised the department that it was ready to move forward with a request to obtain FISA authority to surveil Page. We concluded that the Steele reporting played a central and essential role in the decision to seek a FISA order. As we describe in our report, the FISA statute and department and FBI policies and procedures have established important safeguards to protect the FISA application process from irregularities and abuse. Among the most important are the requirements that every FISA application contain a full and accurate presentation of the facts, and that all factual statements are, quote, scrupulously accurate, close quote. We found that investigators failed to meet their basic obligation that the FISA applications be scrupulously accurate. We identified significant inaccuracies and omissions in each of the 4 applications, 7 in the first FISA application, and a total of 17 by the final renewal application. As a result of these significant inaccuracies and omissions, the FISA applications made it appear as though the evidence supporting probable cause was stronger than it actually was. We also found basic, fundamental, and serious errors during the completion of the FBI's factual accuracy reviews, known as the Woods procedures, which are designed to ensure that FISA applications contain a full and accurate presentation of the facts. Department lawyers in the court should have been given complete and accurate information so they could have meaningfully evaluated probable cause before authorizing the surveillance of a U.S. person associated with a presidential campaign. That did not occur, and as a result, the surveillance of Carter Page continued even as the FBI gathered evidence and information that weakened the assessment of probable cause and made the FISA applications less accurate. We concluded that as the investigation progressed and as more information was gathered to undermine the assertions in the FISA applications, investigators did not reassess the information supporting probable cause. Further, the agents and supervisory agents did not follow or even appear to know certain basic requirements in the Woods procedures. Although we did not find documentary or testimonial evidence of intentional misconduct, we also did not receive satisfactory explanations for the errors or the missing information and the failures that occurred. We are deeply concerned that so many basic and fundamental errors were made by 3 separate hand-picked investigative teams on one of the most sensitive FBI investigations after the matter had been briefed to the highest levels within the FBI, even though the information sought through the FISA authority related so closely to an ongoing presidential campaign, and even though those involved with the investigation knew that their actions were likely to be subjected to close scrutiny. This circumstance reflects a failure not just by those who prepared the FISA applications, but also by the managers and supervisors in the Crossfire Hurricane chain of command, including senior FBI officials who were briefed as the investigation progressed. Oversight by these officials required greater familiarity with the facts than we saw in this review, where time and again during OIG interviews, FBI managers, supervisors, and senior officials displayed a lack of understanding or awareness of important information concerning many of the problems we identified. That is why we recommended that the FBI review the performances of and hold accountable all individuals, including managers, supervisors, and senior officials, who had responsibility for the preparation or approval of the FISA applications, as well as the handling of the Woods procedures. Additionally, in light of the significant concerns we identified, the OIG initiated an audit last week that will further review and examine the FBI's compliance with its Woods procedures in FISA applications that target U.S. persons in both counterintelligence and counterterrorism investigations. The OIG report made a number of other recommendations that we believe will help the FBI more appropriately use this highly intrusive surveillance authority, and that will also strive to safeguard the civil liberty and privacy of impacted U.S. persons. We will continue as an OIG our rigorous independent oversight as these processes move forward in the months and years ahead. That concludes my prepared remarks, and I look forward to answering the committee's questions.
Thank you, Inspector General Horowitz. These Greek names are hard. I just want to give you the opportunity. You made the same mistake I did. I started saying George Stephanopoulos, but you really meant George Papadopoulos, correct?
Papadopoulos, correct.
Okay.
And my apologies to George Stephanopoulos if that's what I said.
Mine as well. Before we start the clock on me, I did want to provide some clarity. I was going to do this in my opening statement, but I think it's best if just a quick little exchange here. In a number of places, not only this Inspector General's report, but also in the mid-year exam, you have a similar statement, I'm going to quote, "We did not find documentary or testimonial evidence that political bias or improper motivation influenced the decisions, fill in the blank." And you've used it in a number of cases. Now, I know we talked earlier about you're pretty confident there was no political bias in the opening of the investigation with Bill Priestap.
Yeah, we did not find evidence, and as to him, we knew who made the decision. We could focus specifically on him.
But you definitely, in both of these investigations, you found political bias.
We found, through the text messages, evidence of people's political bias, correct.
Also, political motivation. For example, Bruce Ord talked about how Christopher Steele was desperate to make sure that President Trump didn't become president.
Well, as to Mr. Steele, that was, of course, a very important part of this discussion, is when they understood his motivations and his potential bias. And we have the November statement from Mr. Orr that he had been told by Mr. Steele that he was desperate to prevent.
So again, so you're not denying there's certainly evidence of bias, there's certainly evidence of political motivation. But what you're saying, this is what I want to clarify, because I think this has been misconstrued and misused, depending on where you put it, that you're not saying that that bias did not potentially influence that. You're just saying you had no evidence that it did. Is that an accurate statement?
We have no evidence that it did. We laid out here what we did to find bias or evidence of bias. We put this report out here so the public can read it, look at the facts for themselves, but we did not find exactly what we said, documentary or testimony evidence of bias.
But
nothing
again,
more, nothing less.
But you're not saying you did not, that it did not. I mean, you didn't find evidence that it did, but you also didn't find evidence that it did. You're not saying that this bias or motivation did not influence. You're not making that declarative conclusion, correct?
Again, I want to carve out the opening and the predication.
Pre-Stapp versus the others.
Because because that decision was was made by one person. We knew who made the decision, understanding that there were questions raised about people above and below him. As to the other decisions, for example, the FISA decisions and the errors and the problems, we don't reach a motivation conclusion precisely because of the concerns we have on that. So I think it's important for readers to read the report themselves. We talked about this before the hearing. Our job as inspectors general is to do what I know all of you expect us to do, transparency, get the facts out there. And that's what we've tried to do here.
So you're leaving it up to the reader, to the American public to judge whether the bias and the motivation that you have uncovered, to what extent did that potentially influence decisions throughout this process?
We're drawing the only conclusions we felt comfortable drawing here, and the public can read, and an informed public is very important for all of these purposes.
Just one final follow-up. What kind of evidence would you require? I mean, literally an oral confession or a text saying, I so hate this guy that I'm going to choose this path versus the other. So
it was very hard to look at all this evidence and obviously, as we all know, get in people's minds. What was the motivation for decisions to be made? What we looked at was who touched the decision. Did we find evidence through text messages, emails, witness interviews? We sometimes do get, not in this case, but we do sometimes get whistleblowers and other people coming to us and saying, I think so-and-so made a decision for an improper purpose. And we as IGs look at that. We were looking for that kind of evidence. As you noted, as to some people, we had concerns about that. Our last report lays out not just as to, for example, Mr. Strzok or Ms. Page, but as to others, concerns about certain text messages. What we were trying to figure out is what was the evidence, who was involved in decisions, and was there evidence linking those biased texts or other evidence connected to decisions? Could we bring them together? That was what we were trying to do.
I know in your report, and you can start the clock now, in your report you say the text messages were not only indicative of a biased state of mind, these are the Strzok Page texts, even more seriously imply a willingness to take official action to impact Trump's electoral prospects. So that's a statement you also make. Okay.
Mr. Chairman, would you yield to me for just a moment?
Sure.
Yep.
Stop the clock.
Yeah. Is it fair to say that there are FBI agents who were pro-Trump and anti-Trump, including some fairly senior people that were pro-Trump and made it very clear that they were?
We found in both reports evidence of political views disassociated from action. And I think that's very important. And I tried to emphasize this last year as well as last week. We're not concluding that someone's biased simply because they supported one candidate or another. Frankly, they shouldn't be using their devices for any purposes that are political. It raises Hatch Act potentially and other issues that are not biased but other legal issues. But what we're looking at are were the comments so significant that it concerned us that they might have caused them to influence decisions they made. And that's where we, particularly in last year's report, where we had far more evidence of text messaging. We had some people who had expressed political views but didn't act on them. Again, here we have some members that we have in here that reference their political views, but no information, and they're not the kind of written texts that suggest a potential state of mind that would cause us concern.
All right, thank you.
I think we have that covered. So my first question, and I'm not asking you to speculate, but based on your knowledge of FBI policies regarding investigation closures, and also based on what you found out that the FBI knew pretty early in the process of that consensual monitoring and what they found out once they finally interviewed the primary subsource, would it have been consistent with FBI and Department of Justice guidelines to close Crossfire Hurricane shortly after the FBI first interviewed Steele's primary subsource in January 2017? And would that have been a reasonable discretionary decision?
So certainly one of our criticisms that we've laid out here is that as the team was gathering this evidence as to the Carter Page FISA in particular, they weren't reassessing it, including primarily, as I'm sure we'll talk about, the information from the primary subsource that was inconsistent with the Steele reporting. We even have in here in the report a reference on page 212 where we've got agents talking with one another about why is Page even a subject anymore. To your question of why are they still looking at him, they were actually asking that question not just as to the FISA, but the foundational question of Carter Page, we're not finding anything as to him. Why aren't we reassessing?
So again, Mike, would have been within their guidelines. Would have that been if they'd done that and you were doing investigation, you go, that was a reasonable discretionary decision to close this thing down.
Certainly, as someone who's done these cases in AUSA and working with agents, if you're getting information that isn't advancing and in fact potentially undercutting or significantly undercutting your primary theme or theory, as was happening here with the Carter Page file, so you'd look at the Carter Page file and say, should I keep going on this Carter Page-related matter?
I believe this is going to be outside, and I think I understand. I know what your answer is going to be, but I want to ask the question: Did in the course of your investigation, did you ever find out how George Papadopoulos was put in touch with Mifsud, Downer, Halper, or Turk?
That was not something within the scope of our review. If we would have seen something in FBI records about that, we would have assessed it. But we were focused, as I said in my opening.
And you saw nothing in the records that would answer those questions?
Find anything that would connect all of that from the FBI side of the information.
According to James Comey's May 28, 2019 op-ed in the Washington Post, Joseph Mifsud, unnamed at the time, was a, quote, Russian agent. Again, did you find anything in the FBI documents that would support James Comey's conclusion about that?
I want to be careful on that because I think if I answer either way, I might be touching on information I'm not sure I can speak to in this setting.
Okay.
But let me be clear, we certainly would have looked to see what the FBI...
We'll follow up in a different setting. Yeah. Did you ever determine why on April 1st, 2016, FBI headquarters directed FBI's New York field office to open a counterintelligence investigation on Carter Page? Did you ever get to the bottom of why that happened?
I'm sorry.
So in April 1st, 2016, FBI headquarters directed the field office in New York to open up a counterintelligence investigation on Carter Page. Did you ever figure out what caused that?
We did, the primary purpose of this was not to look at that investigation. We did get some testimony we describe here about that investigation and what prompted them to open it. It grew out of a Southern District of New York case, but we didn't go beyond that and dig into the files.
So you never found out why FBI headquarters directed that it should not be a sensitive investigative matter?
Again, we didn't go into the specifics of how they precisely decided to open it other than interviewing some of the witnesses to understand a little bit for background purposes.
Neither of Peter Strzok's immediate bosses, Bill Priestap or Assistant Director Steinbeck, wanted him to run the investigation, mainly because of the relationship with Lisa Page, as well as kind of a tendency to go around, particularly Steinbeck, go right to McCabe. But Andrew McCabe overruled that decision. Did you ever find out why?
So we talk about that in the report, page 64 and 65, about that very issue. And Mr. Priestap recalls it as you described. Mr. McCabe We have his explanation in there. Didn't precisely recall certain of the events, recalled some other events, and again, we lay it out. We laid out there what he was involved in terms of selecting as Mr. Priestap described it, having Mr. Strzok stay on the investigation.
On August 25th, Deputy Director McCabe directed Crossfire Hurricane to contact the New York field office for helpful information. It turned out that helpful information was the Steele reporting. Now, this is 25 days before the FBI actually received the first 6 Steele reports. Did you ever get to the bottom of how Andrew McCabe was so far ahead of the rest of the FBI in that?
Again, we asked witnesses about that, including Mr. McCabe, and we had ultimately we weren't able to get to the bottom of exactly what caused that delay or what prompted that call.
Now, McCabe told people he didn't remember doing this, but in fact, McCabe told your team he did not remember details about 26 significant events in your report. Did you find his memory lapses credible? He seemed to be pretty. He seemed to be pretty involved in this investigation. I mean, overruling to make sure Peter Strzok would be named the director, contacting the New York field office. He seemed to be pretty involved, and yet on some pretty significant issues in your report, he just doesn't recall. Do you find that those memory lapses credible?
We did find he was briefed on the investigation, and as you noted, there were several points at the beginning where he was involved. We don't make a determination or credibility finding on that issue.
Okay. Senator Peters.
Thank you, Mr. Chairman. I just want to clarify after some of that line of questioning, just so we're clear for the record, and you can answer these first couple questions with yes or no if that works for you, Mr. Horowitz. Did you find any documentary or testimonial evidence that the decision to open the investigation was political?
We did not.
Did you find any documentary or testimonial evidence that the decision to open the investigation was motivated by bias against President Trump?
We did not.
Your report states that in mid-2016, the FBI was investigating attempts by Russia to hack into political campaigns, parties, and election interference. Is that correct?
Right. We put that in there for background purposes. Correct.
Right. Your report also states that the FBI received information from a friendly foreign government that Russia offered to assist the Trump campaign. Is that correct?
Correct. We lay out the precise words that Mr. Papadopoulos reportedly stated to the friendly foreign government.
Great. Now, your report does outline a number of problems with the FISA process, as you've elaborated on. My question, particularly when it relates to questions from the chairman regarding Carter Page, my question is, did the FISA errors affect the investigation's other 3 subjects in your analysis?
We did not see information from the Carter Page events and the FISAs infecting the others. In fact, part of the concerns that we outline here is the lack of developing of information as to Mr. Page. So it wasn't advancing the investigation precisely for the reasons we outline here, and by definition, therefore, not being of assistance or impacting the others.
So it had no impact on the other investigations?
As to the other 3, we didn't see any connection between this and the others I'll say this caveat, which is the Papadopoulos information was being used in the Page FISAs. And so the extent to which the Page FISAs were not advancing information as to Mr. Page, they arguably weren't advancing information as to Mr. Papadopoulos, because that was the linchpin fact, initially at least, to go for opening all of the cases.
Okay. So as you've identified a number of issues related to how the FBI used the FISA process, certainly those are things that need to be addressed. The director has said that he is working to address. So my question is do you have any idea if, as you are quoted as saying, there were basic and fundamental errors were made in this process? Is there any idea that this is just this is kind of a systemic problem in the FBI, or did this only occur with this particular investigation, or do you think this is much broader that we have to deal with in a broader sense?
Well, as you know, as an IG, I'll speak to what we found here, and that's frankly why we started the audit, because the concern is this is such a high-profile, important case. If it happened here, is this indicative of a wider problem, and we only will know that when we complete our audit, or is it isolated to this event? Obviously, we need to do the work to understand that.
So you mentioned the audit. Could you describe the scope of the audit for us, please?
What we're going to do in the first instance, since we don't know what we don't know, and this is, to our knowledge, the first ever deep dive anyone's taken in a FISA, what we're going to do in the first instance is have our auditors do some selections of counterintelligence and counterterrorism. This was a counterintelligence FISA. We've heard lots of concerns about counterterrorism FISAs, about targeting and other issues there. We're going to take a sampling. We're going to look and compare and see how the Woods procedures played out in those FISAs by comparing the Woods binders to the FISAs and seeing if the same basic errors are occurring there. If they are, then what we'll do is we'll make further selection to do deeper dives as appropriate. But we first want to get a window into these. We have limited resources, and we want to make sure we're targeting them in the right places.
So, if I recall from your testimony here today, is that the errors that were occurring, the fundamental errors and basic errors related to the FISA process, you didn't find any evidence that there was political bias there, no documentary evidence. The errors occurred, and those are troublesome, but you didn't necessarily link those to any political bias. Is that accurate?
So, I want to draw a distinction there. What we didn't find was, as they were considering in August and September whether to seek a FISA, we didn't see evidence there in those communications. But as to the failures that occurred, we didn't find any of the explanations particularly satisfactory, in fact, unsatisfactory across the board. In the absence of satisfactory answers, I can't tell you as I sit here whether it was gross incompetence, and I think with the volume of errors, you could make an argument that that would be a hard sell, that it was just gross incompetence, to intentional, or somewhere in between, and what the motivations were. I can think of plenty of motivations that could have caused that to occur, but we didn't have any hard evidence that I can sit here and tell you, why did these occur? I can tell you they occurred. I can tell you we didn't get good explanations, but I can't tell you why.
But it's conceivable those bad explanations are a result of a systemic problem with the FISA process. So it's difficult, I would ask, it would probably be extremely difficult to answer that question until you complete your further audit to see whether or not this is a systemic problem within the FBI that has to be corrected. It wasn't something just with this particular case. Is that accurate? How would you look at that?
We certainly wouldn't make any conclusion about systemic or not. As to the failures here, in the absence of the satisfactory answers, given how basic some of these were, how fundamental, this was not an error because this was too complex. You didn't understand that the fact you gathered here was inconsistent with the fact you were relying on there in the FISA. These should have been told, and I think you see this in the FISA court opinion yesterday.
Right.
These should have been told. These were basic fundamental errors. It's hard to figure out what the rationale is, which is why we're not sure what the motivation was.
Well, but I just want to clarify that the way you'll know that is if you, as you're looking at other cases through your audit and you find that these are occurring on a pretty regular basis, that may be something that why we have to correct the FBI. The reason they were fundamental is because they're making these fundamental errors in a lot of other cases, and we need to make some reforms. Is that
right? Yeah, no, and it could be right. If you look at the others and you find similar errors and bad explanations there,
right?
It may be one answer. Frankly, if you find no other errors there, that would be particularly concerning, right, as to this one. Why then in this one? So I think we need to understand.
But that's why we need the audit. Right. Thank you.
So I want to just quick consult with committee members here. The vote's been called. I mean, we could continue with this. The next question is Rand Paul, then Senator Hassan, then Rick Scott. Or we could recess, go vote, and come back so we don't miss any of the testimony.
I'd kind of like to get mine done and continue on if we could.
One vote. So it's very easy for us to manage this, but we're going to keep going? Yeah, right. Okay. So what I would suggest is, Rand, you stick around. Certainly Rick, and maybe all of you quick skedaddle and get back. Okay? Then I'll go vote. Senator Paul.
Thank you for coming. And much has been said of bias, and in a town that's full of politics and opinion, it's kind of hard to be anybody without bias. But I do appreciate that you and your team try to avoid having bias in your reporting and try to be as objective as possible. I appreciate that. And I think you and other inspectors general do a great service to our country, trying to figure out and make things better and root out where there are problems. I would say that when we look at bias, I guess the first question would be a short question, just to reiterate and make sure it's very clear. You did find evidence of biased individuals who were involved with the investigation.
That's correct.
Okay. And I think that's very clear. And is it difficult to determine what people's motives are, or whether they're biased or not biased?
It's very difficult.
Right. And so just by saying you didn't find it doesn't mean it didn't exist. It doesn't mean you couldn't have had 15 people very biased who influenced every one of their decisions. You just can't prove it.
We could not prove it. We lay out here what we can prove.
Okay. One specific instance I'd like to ask you about, though. The OGC attorney is the one I think you've referred for criminal evaluation, correct?
I'll just say we've referred to the Attorney General and the FBI Director.
Right. For possible, and that's the possible criminal evaluation. He also had text messages that said, Vive la Resistance. Did you interpret those to be, or what would your opinion, does that show that he might have had some bias against the Trump administration?
Well, he was one of the individuals in last year's report precisely for those text messages that we referred to the FBI precisely for that concern.
But you interpreted that as an evidence of bias. But I guess my question would be, if you saw that he was biased, he's obviously made errors that you think actually may have been intentional. Mm-hmm. Why in that instance would you not be free to say that there's documentary evidence of not only bias but then malfeasance?
That's precisely why we don't say that as to the errors, the failures in the FISA process.
Right, but could you then specifically say the opposite, that actually in this instance there actually was evidence of political bias and evidence of record changing that looks like malfeasance?
There is evidence of both. I agree with you, but we will I want to make sure there's a fair process.
That's fine, and I think the chairman's very correct that the media has misinterpreted what you've said and drawn conclusions that I don't think are accurate as to what you're saying, and people should read the report, and the report is very damning as to the process, whether there's bias or not, there are problems. Now, getting to your solutions, you've suggested that, and I think you're attempting to make valid suggestions as to how the process would be better. I would make the argument that the process cannot be corrected. And the reason I would say this is that the FISA court system requires this high scrupulous nature for the agents, and they are both the prosecutors and supposed to be defense at the same time. There isn't anybody on the other side. And this is not the standard of the Constitution, and we've allowed this to happen because we're going after foreigners, and we just frankly said, well, we're not going to have all the constitutional protections for listening to Gaddafi's phone calls or Saddam Hussein. We're just not going to have all these protections. My point is, we're now getting into something that's at the root of our democracy or of our republic, and that is political debate and discourse in the First Amendment. I don't think the tweaks to the FBI will work. I frankly think what we have to understand is the FISA court's for foreigners. It's at a lower than constitutional level. And so I guess my question to you would be, do you think it's within the realm of the reforms that we should consider is whether or not political campaigns should be investigated using a secret court where there is no legal representation for the defense?
And you raise excellent questions here, and one of the things that we are careful not to do is when we make recommendations to Congress on statutory changes. So we try and work with the process, as you noted. There will be a lot of debate that goes well beyond what we're recommending to try and fix what's existing. There's going to be a legislative look. The FISA court clearly is going to look at some of these issues now. And I do think, and we're prepared to come meet with legislators and talk through these issues as you all consider things that go beyond the four corners of what exists. I think one of the issues here, and we reference this, having been a prosecutor where you go ex parte to a court for search warrants and wiretaps in the criminal process, but you also know that at some point the defense lawyer is going to get those if there's a case made, and there's the potential for a litigation in an open courtroom before a judge with a defense lawyer cross-examining. And that's that alone, that understanding that could happen,
Right.
has some effect.
Yeah, and I agree. And I think if you don't have that in the FISA system, no matter what you do, you tweak the system. When you're telling me it requires FBI agents to always be scrupulous and never have bias enter into that, we're trying to prevent bias from entering in. I think it's a standard that's too high for individuals to take, and there will always be people on both sides of the political spectrum who may let their biases enter into that, and the check is to have a defense attorney, to have a public trial. And secret courts really were not intended to examine crime in America or to examine political campaigns. And I think that's the thing that needs to come out of this, is that we don't, and this is why I don't fault your recommendations for FBI process to make it better. There's a big danger that we take that politically and say, oh, that's the end answer to that. No, the lesson to me on this is that, and I do believe both sides could be equally culpable of this, is that we should not subject our political campaigns to secret courts and to secret warrants and secret surveillance. And there are all these questions still of, were all these encounters that Papadopoulos had just accidental? Did the government instigate these encounters? And if they did, that's very, very troublesome to me, that our own government would be sending informants into campaigns to try to have chance encounters with different people. So I'm very, very worried about it, and I hope other members of the committee will consider, as we look at FISA reform, that what we have to do is Americans shouldn't be caught up in this. American citizens were not the target of this, and even American citizens who talk to foreigners. Can you imagine in campaigns moving forward that if you're pointed to a high-level foreign policy position, is there a likelihood that you may have talked to Russians or Chinese in your career? If you've been in a foreign policy career for 40 years, you've talked to many Russians. And so to say you're an agent, well, he had 16 conversations with different members of the Russian government. Is that enough to open like a FISA process into that he might be a foreign agent? And it's not the Constitution. It's showing that you have evidence that someone may be related to a government. It isn't evidence of a crime. And so I think we ought to really consider as we move forward that this is not the appropriate vehicle for investigating political campaigns. Thank you.
And if I could just add on that, Senator, I think one of the things also here that we uncovered and learned as we did this, for example, you mentioned the confidential human source issue, separate from the FISA. The absence of rules there applies whether this was counterintelligence or criminal. There did not need to be notice to the department, even if had this been criminal investigation. So I think there are some issues here that cover broader than just the FISA issue that you've raised and concerned about.
Senator Hess, I'm assuming you voted. I did. So we're doing this as the vote's going. I actually asked Senator Scott to stay. So if you don't mind, I'd like to give it to him so he can go vote. Okay. So Senator Scott.
The FBI seeks secret surveillance warrants after you pointed out a series of flaws in the FBI's efforts to monitor a foreign Trump campaign advisor. I think it's very important that safeguards be put in place to prevent a politically motivated rogue agent or agents from being able to manipulate any processes to pursue their own agenda. We had the Parkland shooting down in Florida. We lost 17 wonderful individuals there, and after that, FBI director did the right thing. He held individuals accountable at the FBI, and I had the opportunity to go out, as I told you, out to West Virginia, and I saw some of the processes that they've worked really hard to improve. Now, the errors committed by the FBI and abuse of authority presented in your report should alarm every American. Federal officials motivated by political bias and hatred for our president abused the FISA process in order to surveil people affiliated with the campaign of President Trump, and that's wrong. We're talking about liberal FBI officials abusing their power in an attempt to discredit and undermine the legitimacy of a candidate and his campaign. We should all be greatly concerned about this, and I think you brought this up in your report. Where was the oversight? Where was the oversight when the FBI didn't bother to confirm any of the claims in the Steele dossier before presenting them to the court as evidence to surveil Carter Page? Where was the oversight while the FBI was making 7 key errors or omissions in its original FISA application and 10 more in the 3 subsequent applications? Again, where was the oversight? It wasn't there. The decision whether to open this investigation was a discretionary judgment call left to the FBI. So, Mr. Horowitz, to your knowledge, has the FBI ever spied on any other presidential campaigns? And if so, which ones?
So we didn't go and look, Senator, historically at what other investigations the FBI conducted of various campaigns, so I'm not in a position to really speak to that.
Do you know of any investigations that have ever happened to see if there have been investigations of presidential campaigns or
certainly, as I sit here, I'm not aware of any surveillance that was done or use of confidential human sources, but I certainly can't say it didn't happen. I just can't tell you as I sit here that I know of any.
Okay. I know some people don't like the word spying, but I think that's exactly what Comey's FBI did. It's very similar to the Obama administration's IRS deciding to target conservative organizations. I think the business of weaponizing federal bureaucracies for political purposes is dangerous and disastrous. I can imagine any sane person really wanting to go down this road. I don't know anybody I work with that wants to do this. So can you just go through some of the recommendations you think that are the most important ones that the FBI has got to do to make sure this doesn't happen again?
Well, I think first and foremost, there needs to be a change in practice and policies that involves consultation and discussion with the department lawyers before moving forward, whether on opening a case or involving these kind of constitutional issues or sending in confidential human sources. The level of discussion, I did public corruption cases when I was a prosecutor in New York many years ago, and you would want to talk through very carefully before moving forward in a case like this, and on all steps, both the opening and the investigations. On the FISA side, there has to be a fundamental understanding that decisions about evidence that is undercutting, inconsistent with the theory of the case, has to go to the lawyer who's handling it for the department, and has to move up the chain in the Justice Department, because they have to make the judgment calls. They're the gatekeepers. They're the ones who are there to understand, is there enough for this FISA or isn't there? And if there is, we've got to make sure this application fairly represents to the court all the evidence and all the information. That is what didn't happen here, and that's, I think, why you see the FISA order, the court order yesterday.
Do you think the FBI is going to make the changes that they need to?
I certainly understand that from Director Wray, that is the plan.
Okay. You think he's committed?
Yes. Everything I've heard, he has made it clear he's committed to it.
Given the abuses that were found during this investigation, what should the vetting process be for assets and criminal informants? What do you think
well, there clearly on the FBI side needs to be a better process or a more effective process and understanding in place on how to vet individuals and how to make sure that managers are supervising. And the reason we made the referrals for accountability of the supervisors is this is not only a failure of the line agents, this is a failure of management from the first level all the way up to ensure hard questions are being asked. When you're running something like this, you've got to ask insightful, targeted questions. You've got to know the answers, and you've got to make sure that managers understand what their responsibilities are. So on the easier end is training. On the harder end is making people realize that they can't be making all these discretionary judgments for themselves. Other people need to know about them.
Mr. Horowitz, to your understanding, was Christopher Steele ever polygraphed?
I don't believe we saw any evidence of that.
Does that surprise you?
I'd probably want to talk further with my team about making sure I understand what the rules are at the FBI in terms of doing it, but you could see, if presuming it's within the rules at the Bureau to do that, it's a certainly reasonable question to ask.
So when the FBI finds an asset that they determine not to be credible, what should they be doing?
Well, they should cut that person off as a confidential human source.
Do they have an obligation to go back and tell everybody that was providing information based on that now not credible source that they were wrong?
They have an obligation to close the person, put it in what's called the Delta file, so it's in the FBI system, so that every single person who's relied on that informant can see that information. It's one of the criticisms we have here, is that not all information went into the Delta system as they were learning information about Mr. Steele. And as needed, they should be alerting not only the agents who've relied on it, but if it's criminal, they should also be telling the prosecutors what they've learned.
Thank you. Thank you. Senator Hassan, thank you again for letting me go.
My pleasure. Thank you, Inspector General Horowitz, for being here. I'm grateful to the chairman and the ranking member for having this hearing. And Mr. Horowitz, I also just wanted to thank your team for all of their extraordinary hard work, because I think the role of Inspector General is incredibly important. So let me just start with a couple of general questions about the tools that you all have to work with, and really the function that you perform. First of all, I believe you all do a great service to the country. Inspectors General not only evaluate federal programs and spending to ensure that taxpayer dollars are well spent, but they also confront wrongdoing that threatens to undermine our democratic institutions and the specific missions of the agencies that they serve. Consequently, Congress has to do everything it can to support the work of inspectors general and establish safeguards to protect their work against agency interference or political influence. So, Mr. Horowitz, can you discuss the importance of maintaining the independence of the Office of the Inspector General as it reviews agency actions and makes recommendations for improvements? And in particular, how does maintaining that independence help you do your job?
Thank you. Thank you, Senator. It's foundational to what we do.
Right.
This report has credibility because the folks who work on it behind me and who've worked on other reports go at it in just the down the middle of the road way, completely independent. We want to put forward information so the public can make its assessment of what happened with the government program, whether it's FISA, whether it's a taxpayer-funded program of another sort. But we're all about transparency, putting information out there, and not being swayed by what maybe the FBI or the Justice Department leadership want to see happen or want to see a particular outcome. We've got to be completely independent of that, be able to lay out what we think. The Attorney General disagrees with our finding on predication. That's fine. I didn't take this job to always agree with the leadership of the Justice Department. That's not what this job's about. And that has to be built into the system, and there's got to be respectful disagreements.
Right.
But there's got to be that ability to have disagreements.
Great. Well, thank you for articulating that so well. It's something I think we need to stay focused on. And now let's get to a couple of the tools that I'd like to ask you about. The Inspector General Act gives IGs numerous tools to conduct their evaluations, audits, and investigations in a thorough and objective way. However, additional tools may be required to adequately perform what's really important work. One of these additional tools is the ability of the IG to subpoena witnesses who operate outside of the agency or its programs, including former federal employees. How would the ability to compel testimony from these witnesses enhance the investigative capabilities of the IG community?
So it's a critical tool that we've advocated for many years. This committee has been very supportive of us getting it. So, as an example, in this review, we had two witnesses who would not speak with us, Mr. Simpson, Mr. Weiner, and we had no ability to get their testimony. Most importantly also, though, partly the reason this took 18, 19 months is because many witnesses initially declined to speak to us and only towards the end of the investigation re-engaged and said now they were interested in speaking with us. We weren't going to turn down their testimony. That required us to extend our timing. So having subpoenas not only would have allowed us to get evidence we didn't get, but it would have allowed us to move this more rapidly to a conclusion. Very importantly, on programs that cost the taxpayers money, grant recipients, contractors of the federal government, those are people who are not federal employees, who don't have an obligation to cooperate. That would be very helpful in that regard. Former employees, I could go over and over and over with you, and we've sent many examples to the committee, of individuals who engaged in misconduct at the Justice Department and retired on the eve of us questioning them. And then they don't come in. And valuable evidence is lost. Sometimes they are the subject. Sometimes, frankly, they're the critical witness. They retire, they have their pension, they move on. And in fact, actually, if they become contractors, they can come back and work for the federal government and we can't subpoena them in that position.
Okay.
So there's a lot of reasons why that's a very important provision. And by the way, the Defense Department IG has that authority.
Okay.
It's been used very sparingly in all the years because when you have the authority, people work out a voluntary arrangement to come in and talk to us.
Right, of course. Well, thank you for that explanation, and that's something I hope we can work on in a bipartisan way. Another one of the tools that could aid your office in particular is the ability to investigate misconduct of Department of Justice attorneys. Can you provide us with more background on why this particular policy is in place and whether, in your view, it's an appropriate exception to your authority?
Absolutely, and thank you for asking about that. So this has been something we've advocated for 30 years since we came into existence in 1988. The deal that was struck in 1988 that allowed the Justice Department to have an IG with the Attorney General at the time was to carve out lawyers, and actually at the time back to carve out the FBI and the DEA from oversight by the Independent Inspector General. So when we started, we largely oversaw the Immigration and Naturalization Service, which was at the department at the time, and a few other entities. In 2001, at the time it was within the discretion of the Attorney General to change that, Attorney General Ashcroft, after the Aldrich Ames scandal, gave us authority over the FBI and DEA. Congress legislated that a year later. Lawyers continue to be carved out. The discretion to change that is no longer with the Attorney General. It's Congress that would have to change the law. We're the only Inspector General office that I'm aware of that doesn't have authority over misconduct by any employee in the agency they oversee. And so if the misconduct is by the line prosecutor in a courtroom, prosecuting someone criminally, to the Attorney General, we don't have the authority to look at that. That goes to the Office of Professional Responsibility, which doesn't have the statutorily protected independence and transparency that we have.
Well, thank you. It's my understanding that legislation is required to provide the IG community with these tools, and I look forward to working with you to explore this further in order to find a bipartisan way to strengthen the investigative capabilities of the IG community. You really do important work, and we're very grateful. Thank you.
Thank you, Senator. And I just add on that OPR bill on the Office of Professional Responsibility and our ability to oversee prosecutors. The House has passed the bill, voice vote, bipartisan, unanimous. Senator Lee has a bill pending in the Senate with bipartisan co-sponsorship, and I know this committee has cared deeply about it and look forward to working with you on it.
Well, thank you, and thank you, Mr. Chair.
Senator Hawley.
Thank you, Mr. Chairman. Mr. Horowitz, I see that the FBI continues to persist in characterizing the problem related to the surveillance issues here as limited. And I see the FBI director's statement yesterday, the FBI statement yesterday makes it sound as if there's a limited problem. So let's just talk a little bit, if we could, about the scope of this problem with the FBI and how it is that the FBI came to be intervening in a presidential election while the election was ongoing in the fall of 2016. First, let me just ask you, when it comes to FISA warrants, surveillance warrants, are the targets of those warrants given an opportunity to defend themselves in court at the time the warrant is sought?
No.
So the court relies on who to establish the facts?
The FBI and the Justice Department.
So there's nobody there to contest the facts. I mean, the court only hears from one side. Is that correct? Is it normal in your experience, your knowledge, for the FBI to use as the principal basis for a surveillance warrant political opposition research paid for by a major political party?
I can't say that we've looked at any other FISA.
Have you heard of that being done before?
I haven't heard of it, and I can tell you there was obviously, as we lay out here, concern at the Justice Department among the lawyers involved as to that question.
And indeed, the FBI, of course, knew very well the nature and source of this Steele dossier. On October 11th, 2016, after they were asked 3 times by a DOJ attorney, the FBI responded that Steele, and I'm quoting now, had been paid to develop political opposition research. This is right at the time that the FBI was going to the FISA court and asking for a surveillance warrant in the middle of a presidential campaign, correct?
That's correct.
So the FBI absolutely knew where this was coming from. What about the number of people involved? How many people at the FBI were involved in misleading the FISA court by your count, your estimation?
We don't have a precise number of exactly who knew what when, but there were 4 different FISAs. There's a case agent. There's a supervisory agent who are reviewing each. There was some overlap, so it's not 8. I think it's either 6 or 7 who had both of those responsibilities, some of which, to be fair, were more egregious than others in terms of the mistakes and the failures that occurred. And then, of course, as we note here, the reason we refer people up the chain is there is information flow up the chain. And even though those individuals didn't have direct responsibility under the Woods procedures, as managers and supervisors, we believe they had a responsibility to ask the probing questions they should have been asking and followed up on information they were getting to make sure they were in a position to effectively supervise.
I want to come back to the information flow up the chain in just a second. You say on page 65 of the report there were over a dozen agents, analysts, and one staff operations specialist in the original Crossfire Hurricane team, which would have included at least 9 FBI agents and supervisors involved in overseeing the Carter Page investigation. By my count, just what you've said in the report, looking at an organizational chart, we're talking probably at least a dozen individuals who were directly involved in the Carter Page warrants. The 4 times. Does that sound approximately correct?
That is. In fact, there's the org chart here at the end of Chapter 3. There are
Exactly.
3 different organizational charts, and people can see and follow this for themselves. But
So we've got about a dozen people at the FBI directly involved. That's a lot of people. The FISA court pointed out yesterday that an electronic surveillance application under federal law must be made by a federal officer in writing upon oath or affirmation, and those individuals swear to the facts of the application. Yet we now know that in October and then 3 times late, October 2016 and 3 times in 2017, these individuals deliberately, knowingly misled the FISA court. I mean, that's really the nicest way to put it. Basically, they lied to the FISA court to get a surveillance warrant of an American citizen. Why would so many people do that?
so we lay out here the reasons. As I said, there are multiple teams. There are some more senior people, more junior people. We obviously try very carefully to lay out who knew what when and which people. So I want to be careful enough.
Were they just all incompetent? I mean, all of these people, were they just couldn't they didn't know? I mean, they were competent enough to deliberately mislead the FISA court, to change submissions to the FISA court, to alter emails. I mean, so that doesn't sound like they're very stupid to me. But I mean, what's the explanation? Why over time? Why would all of these people 4 times over the space of half a year deliberately mislead a federal court?
So we ultimately we don't make a conclusion as to the intent here. So I want to be clear about that. But that was precisely the concern we had, is what you lay out. There are so many errors. We couldn't reach a conclusion or make a determination on what motivated those failures, other than we did not credit what we lay out here with the explanations we got.
Yeah, so it certainly wasn't the reasons that they offered you.
We didn't credit
saying.
that. And frankly, this is one of the reasons we weren't able to, but didn't reach a conclusion, is we now have the court weighing in and the court wanting to understand what happened here as well.
Yeah, so I think the scope here is what really alarms me. The number of people directly involved at the FBI, the repeated decisions to mislead, outright lie to the FISA court, and the total implausibility of the explanations that these people offered you. I mean, again, maybe they're incompetent or maybe they had an agenda here, and I just want to put a fine point on that. Was it your conclusion that there was that political bias did not affect any part of the Page investigation, any part of Crossfire Hurricane? Is that what you concluded?
Reach that.
Because I could have sworn, in fact, I know for a fact that I've heard that today from this committee, but that's not your conclusion?
We have been very careful in connection with the FISAs for the reasons you mentioned to not reach that conclusion, in part, as we've talked about earlier, the alteration of the email, the text messages associated with the individual who did that, and our inability to explain or understand to get good explanations so that we could understand why this all happened.
I think we're left with really, I mean, it's two possibilities here. You have 3 different investigative teams, as you testified earlier. You've got a dozen people at the FBI. You've got the decisions made over time to mislead the FISA court. Either these people were really incompetent and bad at their jobs, or they had an agenda that they were pursuing. And having an agenda, I don't care what word you put in front of it, political agenda, personal agenda, but whatever it is antithetical to democracy. Let me just ask you about the information flow up the chain. We know that Director Comey was briefed about Crossfire Hurricane in August of 2016. Who else knew about this? On October 14th of 2016, we know that Deputy Director McCabe gets a text message saying that the Deputy Attorney General wants to be part of the meeting, and the White House has asked the Department of Justice to host. Who at the White House knew about the Crossfire Hurricane investigation?
So, as you know, we're not the IG, the Inspector General over the White House or the Executive Office of the President. And so what we have access to are the records at the FBI and the Justice Department. So I can't answer questions unless about that as to who knew or who was involved beyond people in the Justice Department and the FBI.
I just find it very hard, I'll say in closing, Mr. Chairman, I find it very hard to believe that the Deputy Attorney General of the United States, the FBI Director, all knew about this, but that the senior leadership, the Attorney General herself, or for that matter, the President of the United States, would not know about a surveillance program of a major party candidate in the midst of a presidential campaign. I mean, that just boggles the mind. Thank you, Mr. Chairman.
Thanks, Mr. Hawley. By the way, good line of questioning. I want to take this opportunity real quick to put a little meat on the bones here. You talked about mid-October. October 11th and 12th, Christopher Steele's meeting at the State Department with Kathleen Kovalek and Jonathan Weiner, who refused to cooperate with this investigation. It's also the same day, on October 11th, that Stu Evans is raising questions about Steele, going, where's this coming from? 3 times asked the question, did not get a satisfactory answer 3 times. It's also within the, I think the next day, October 12th, 11th and 12th, Lisa Page is texting Strzok and McCabe saying that there's problems with Stu Evans, and, oh, by the way, if in order to break down his resistance, my words, not hers, basically she might have to use McCabe's name to get Stu Evans to basically agree to letting this FISA warrant go through. So talking about information up the chain, you got McCabe, you got Strzok, you got Page, that little cabal. I know they said they didn't call themselves a secret society, but it sure sounds like they had a little bit of a cabal going here, and that's being really influenced. You can see it right there in those texts. That's why the timeline is so important. Take a look, line up these unvarnished truths that the texts reveal, combined with the timeline of events happening. It's pretty revealing. Senator Langford.
Mr. Chairman, I'd like to ask unanimous consent that we enter into today's record the Foreign Intelligence Surveillance Court order that they put out yesterday.
Without objection.
It's pertinent, obviously, to this conversation today. Mr. Horowitz, thank you. Thanks for your leadership, not only at SIGI, but also, obviously, with what you're doing there at DOJ. I appreciate your whole team and the work that you continue to do. You used the term, when talking about the mistakes that were made, saying there were so many mistakes, this was either somewhere between gross incompetence to intentional. But you didn't try to be able to determine the motivation of all these. It gets a little more harsh when the FISC responds back to this in the letter that they sent out in their order yesterday. They said because the conduct of the OGC attorney gave rise to serious concerns about the accuracy and completeness of the information provided to the FISC in any matter in which the OGC attorney was involved, the court ordered the government on December 5, 2019 to, among other things, provide certain information addressing those concerns. Then this. The FBI's handling of the Carter Page applications as portrayed in the OIG report was antithetical to the heightened duty of candor described above. The frequency with which representations made by the FBI personnel turned out to be unsupported or contradicted by information in their possession and with which they withheld information detrimental to their case calls into question whether information contained in other FBI applications is reliable. One of the reasons this hearing is so incredibly important is because what this group did at the FBI not only took our nation down years of turmoil, but they're now calling into question every FISA application, and I'm confident every attorney is going to bring this case up and to say we can't rely on the FISA process now and will cause turmoil in the FISA court for a very long time. So the Crossfire Hurricane team not only did damage to our nation, did damage to our justice system, and potentially damage to what we're doing in counterintelligence and counterterrorism. So we appreciate your work because this is incredibly important to actually get to the bottom of this process. Can you compare the quality of work as you went through the interviews with the Crossfire Hurricane team at HQ, at headquarters, with the Washington field office and those agents and the quality of their work? Did you see the same number of mistakes made in what was done between the Crossfire Hurricane team and the Washington field office team?
So many of the problems that come up here flow from the earliest parts of the investigation, which were the headquarters-based teams. As you know, the teams got mixed as they went along. It went out to the field and it came back at various times, which is a problem we identified here. Most of the problems are occurring at the headquarters-based times when the teams are together. It's not exclusive because it goes to the field as well.
So the Washington field office seemed to handle documents and procedures better than headquarters handled it.
I think on balance that's a fair comment, although frankly we don't go into trying to
Right, you're not
that.
trying to compare the two. I'm asking for an opinion after you have gone through the process.
And there are so many problems here, we decided not to sort of
Try to
parse
separate it out.
exactly where things might have been not as problematic as others.
Let me follow on to what the chairman was talking about with Jonathan Weiner. The meetings in the State Department are very, very curious to me. That Steele somehow either initiates or he says was invited by State Department officials on October the 11th to be able to come sit down with officials at the State Department. He made very clear he's trying to get documents into the public eye before the election and to try to get all these things made public. That meeting happens on October the 11th. On October the 19th, Steele delivers to an FBI handling agent what he received from Jonathan Weiner from the State Department. So Steele is coming to make his case to the State Department. He makes his case. Apparently Jonathan Weiner then takes a document, gives it to Steele since he is getting things out into the public, and he sends that out. So someone from the State Department is trying to get out into the public what he described as a friend of a well-known Clinton supporter who received this from a Turkish businessman with strong links to Russia. So apparently someone from the State Department is taking a foreign document or a foreign source, getting it to Steele, who he knows is trying to get it out into the public. Were you able to close the loop on what that document is, how that happened, where that document came from?
We did not, and partly the issue, as you know, is the inability to talk to Mr. Weiner about where the document came from, that meeting, those connections, but also our access here and our review here was focused on FBI conduct and conduct by FBI personnel.
So just to clarify on this, this is very apparent to your team, though, that this is someone in State Department trying to take a foreign source document and trying to get it into the public to affect the campaign against Mr. Trump.
I can only tell you what we gathered here. We didn't have a chance to question people on it, so I don't want to be careful. We didn't reach conclusions. We're just presenting.
You're just saying what you saw at this point.
Right.
Bruce Orr is very curious in this process. The FBI, quote unquote, cuts off relationship with Steele early November and then makes it official the 17th of November of 2016, saying we're going to have no more contact with Steele at all. But yet the next day, the FBI, for the first time, pulls Steele's file, and they're still going through this after they've, quote unquote, cut him off. And then within days, Bruce Orr is then doing back-channel communications with Steele, and they continue to maintain back-channel communications with Steele. So was Steele cut off as a source, or was the Crossfire Hurricane continuing to use him as a source, just not officially?
Yeah, we concluded the latter, that while he was cut off officially in FBI records, the FBI continued to meet with him through Bruce Orr as the conduit on 13 different occasions.
Why would Bruce Orr continue to be able to meet with him, and why would he continue to be tasked to do that?
Well, let me just be clear. He wasn't tasked to do it. There was, as he said, he understood what the FBI was looking for from him. But he was able to do it because there were no clear rules that prohibited him from doing it, and he intended and desired to do it. There was nothing that restricted him.
He maintained that. On page 188 of your report, you make this comment that Steele tasked his primary subsource after the 2016 election to find corroboration for the election reporting in the primary subsource, but he could find zero. He reported that to the FBI. He could find zero. He reported that to the Washington field office when they met with him in May of 2017. What I'm trying to figure out is Steele is tasking his subsource to go find corroboration after the election is even over. This was at least a month through this process and cutting off from the FBI. Who is tasking Steele to continue to go chase down more information?
We don't have evidence as to anybody specifically tasking Steele to go chase down evidence, but it's pretty clear from what we're laying out here that the FBI is from day one was asking questions about the corroboration for the Steele reporting and not getting it. So it wouldn't be surprising that Steele was still trying to see if anybody could find corroboration so he could demonstrate that there was support for his reporting when, in fact,
It was
really
zero.
out here, that wasn't what was happening.
It was zero, and it was known immediately by FBI at that point that there was zero corroboration for this. In fact, the State Department personnel, even when they met with Steele, noted that he had his facts wrong, even what he was presenting at that point, and they knew it all immediately.
They referenced, I think it was the purported
Right.
Miami consulate, that there was no such Miami consulate.
All right, thank you. Thank you, Mr. Chairman.
So, Senator Langford, just real quick, your line of questioning again reveals the shortcomings. Again, not because of Inspector Horowitz's fault, but just the fact that he is constrained in terms of what information he can really gather, which is why I'm basically reaffirming to you our committee's investigations have kind of combined. Senator Grassley in Finance, Senator Graham in Judiciary, and this committee. We've begun the process of requesting voluntary interviews on a host of different issues. This is just one of the areas. Again, our investigation started with the Clinton email scandal, kind of morphed into this because the same cast of characters moving into this. So as I said in my opening statement, I'm not going to stop our oversight, our investigation, until I get all the answers to all the questions. The ones you and Senator Hawley raised are very valid, but again, the constraints of inspector generals, the way they are pretty well siloed in their departments, really prevents those questions being answered, even though it's an 18, 19-month investigation. So we'll continue our efforts. Senator Carper.
Thanks, Mr. Chairman. Mr. Horowitz, very good to see you. Thank you for your service to our country for how many years?
7.5.
Does it seem longer?
But it's 7.5.
We're glad you're here. We appreciate the work you're doing and the leadership you provide. And some of the folks standing by, are they part of your team?
Yes.
Would you all raise your hands, please? All right. Thank you very much. I think it was Thomas Jefferson who once said, if the people know the truth, they won't make a mistake. Think about that. If the people know the truth, they won't make a mistake. Sergeant Joe Friday on the TV show Dragnet said it differently. My sister and I used to love that show. And he would be making a visit to someone to try to get information from a man or a woman on a crime or an investigation. And he would always knock on the door. They'd open the door, and he'd say, just the facts, ma'am, or sir, just the facts. And so that's what we're interested in. For a long time, there's an older Methodist minister in the southern part of Delaware in a town called Seaford. His name was Reynolds, Reverend Reynolds. And when I was elected governor in 92, he was nice enough to come and visit me and just give me some advice. And one of the pieces of advice he gave me was, he said, Governor, just remember that to keep the main thing. And I said, pardon me? And he said, the main thing is to keep the main thing. And it took me about 2 years to figure out what he was talking about. But I'm reminded of those words today as we try to figure out the truth and to figure out what is indeed the main thing as it flows from your investigation and your work. In preparing for this hearing, I was speaking of Methodist ministers. I was reminded of a verse of Scripture, I think it might be in the book of Matthew, that warns those who see the speck in their brother's eye, but don't consider the beam that's in their own eye. And over the past few years, the media and some of my colleagues have focused extensively on text exchanges between FBI officials Lisa Page and Peter Strzok, which have been cited as proof of political motivation behind the Crossfire hurricane investigation. But Mr. Horowitz, your report, I believe, notes that other agents exchanged pro-Trump texts and instant messages during the course of the investigation. For example, one supervisory special agent wrote in November 2016, I think it was just after the election, that he was, this is a quote from him, was so elated with the election, close quote, and compared election coverage to, quote, watching a Super Bowl comeback, close quote. He later explained his comments by stating that he, quote, didn't want a criminal to be in the White House, close quote, referring, I presume, to Hillary Clinton. Mr. Horowitz, this agent was supervising the use of a confidential human source in the investigation. Is that correct?
So the individual was in a field office with a confidential human source who provided certain information but wasn't ultimately used by the Hurricane investigation.
All right. And you found other examples of pro-Trump exchanges between FBI personnel. Is that true?
Yes, generally.
Mr. Horowitz, did you or your team find any evidence that the agents who exchanged pro-Trump messages were influenced by political bias?
We did not find evidence of action there. And again, as I mentioned earlier, we were very careful to separate out general statements pro or anti a candidate compared to text messages that went a step further and suggested some intent potentially to act on them or that had wording that was concerning. FBI employees, like any other employee in the federal government, are allowed to have personal views on which candidate they support or don't support. What they can't do is act on them. What they've got to do is check them at the door before they get to work. And that's what we were trying to sort through here.
Yeah, I think that is the main thing. All of us have our political views. We certainly have them on this committee and in the body where we serve. And the question is, to what extent do they impede or promote our ability to get things done? But I'll just ask the question again. I just want to make sure I understand. Did you or your team find any evidence that the agents who exchanged pro-Trump messages were influenced by political bias?
No, we did not.
All right, thank you. And this is consistent, I believe, with the standard of behavior one would expect from FBI professionals. Is that right?
That's correct.
Yeah. And similarly, did you find any evidence that political beliefs affected the work of Mr. Strzok and Ms. Page?
On this investigation, what we looked for very carefully was whether they had the ability to impact the decision specifically. And on the issues we looked at, the confidential human source decisions, the FISA decisions, and the opening, we found that they were not the decision maker on them, so that we could segregate out their views and their activities from those decisions.
All right, thank you. Let me just follow up. During your appearance before, I think it was the Senate Judiciary Committee last week, Mr. Strzok and Ms. Page were described by some of my colleagues as, quote, the people in charge, close quote. But a witness your team interviewed stated that Mr. Strzok was, in fact, not the primary or sole decision maker on any investigative step in Crossfire Hurricane. Witnesses also stated that Ms. Page, quote, did not work with the team on a regular basis or make any decisions that impacted the investigation, close quote. Is it fair to describe Mr. Strzok and Ms. Page as the, quote, people in charge, close quote, of the Crossfire Hurricane investigation?
So Ms. Page was not in the chain of command at any point in time. Mr. Strzok was in the chain of command, so he did have supervisory authority for a period of time. He rotated off the organizational chart in roughly January when the second team came into being, and there were a series of problems that occurred after that as well. And so I think he's in a different position in terms of the chain of command, certainly, than she was.
All right. In March 2017, President Trump alleged that, quote, Obama had my wires tapped, close quote, in Trump Tower just before the victory, close quote. Later, he retweeted a statement that the, quote, DOJ put a spy in the Trump campaign, close quote. Attorney General Barr repeated these accusations in April of this year when he testified that he thought, quote, spying did occur, close quote, on the Trump campaign. And I would just ask Mr. Horowitz, did you find any evidence that the FBI engaged in spying on the Trump campaign?
So we're very careful to use the words, the legal words that are used here, which is surveillance. There was the Carter Page surveillance that we've identified here. We did not find evidence of other court-authorized surveillance. We found the confidential human source activity that we detail here and didn't find additional confidential human source activity prior to the election.
If I could close with this, did the report find that the FBI engaged in surveillance of Trump Tower?
We did not find evidence of surveillance on Trump Tower.
And did the report find that any monitoring of Trump campaign officials occurred without necessary FBI approvals?
all of the monitoring activities were approved.
And is it fair to say that the statements by President Trump and Attorney General Barr that I've described are incorrect?
Again, we don't use the term spying or not. We're looking at whether there was court-authorized surveillance or not.
All right.
So
Thank you so
we'll
much.
stick to what we have here.
I want to go back to October 11th's activities. After being asked 3 times by Department of Justice Attorney Stu Evans, the FBI finally responds, quote, that Steele had been paid to develop political opposition research. In your report, you write that Strzok has advised Page support from McCabe might be necessary to move the FISA application forward. Strzok texts Page, currently fighting with Stu for this FISA. The following day, Lisa Page texts McCabe, I communicated you and boss's green light to Stu. I communicated, I think it's your, and boss's green light to Stu earlier. I've not heard back from Stu in an hour. I will invoke your name to say you want to know where things are. Isn't that pretty high-level pressure on Stu Evans by Peter Strzok, Lisa Page, and Andrew McCabe?
Yeah, there was certainly that effort, exactly as you described. What ultimately happens is McCabe speaks with the head of the National Security Division about it. So they ultimately don't need to do what they're talking about here. But that is absolutely what they're talking about.
I want to go back to pick up a little bit what Senator Langford was talking about with Bruce Orr. These are quotes in your report by senior Department of Justice and FBI officials describing Orr's ongoing interactions with Steele and the FBI. And these just basic descriptions of how these officials thought about it. Quote, outside of Orr's lane, they were stunned, they were uncomfortable with it, out of the norm, bad idea, raised red flags, flabbergasted. FBI should have alerted DOJ. Shocking, inconceivable. That's, again, those are a lot of senior Department of Justice FBI officials. What was interesting is how Andrew McCabe responded to Orr's activity. He said, this is a responsible thing to do. How do you explain that discrepancy from most of the FBI and Department of Justice officials and Andrew McCabe thinking, not a problem, it's a responsible thing to do?
Yeah, look, I can't explain why that view would be there. I think it's perfectly understandable why, if you are in the Deputy Attorney General's office, whether you're the Deputy Attorney General or right below the Deputy Attorney General, to have someone on your staff doing what was going on and not telling anybody is highly problematic. And as we point out here, the net result of that is the Deputy Attorney General was signing a warrant that did not include key information that someone on her staff knew and had told the FBI, but the FBI had not come back and told the Justice Department. That was the net outcome of that. That's a problem.
Well, again, I'm seeing Andrew McCabe's fingers all over this thing. I'm also seeing him saying can't recall 26 times on significant issues. I'm not buying it. Let me go back to State Department involvement. I realize that you're limited, but I just want to ask some questions. Are you aware of why high-level State Department officials meeting with Steele and forwarding his reporting to the FBI? Why were they?
The only thing I can say is from speaking with Ms. Kavalek, it was because she thought she had to tell them because they needed to know. But as to the others, why they were doing what they were doing, I don't know the answer.
Did you obtain any information, meeting notes, or any other documentation based on those meetings and contacts?
We obtained certain information from the State Department, including, for example, Ms. Kavalek's notes, and we were able to speak with her.
You did request interviews with Jonathan Weiner, right?
Correct.
Do you know why he refused to cooperate?
I don't know.
Why did you want to interview him? What information did you feel he had that you wanted to know?
Precisely because of his interactions with Mr. Orr and Mr. Steele, much like we went to talk with Ms. Kavalek, because we wanted to tie off an understanding as to what was happening between the Justice Department and the State Department.
On September 30th, 2016, Peter Strzok texts Lisa Page, quote, remind me tomorrow what Victoria Nuland said. Did you ever find out from Lisa Page what Victoria Nuland had told her somewhere on or about September 30th?
I don't recall as I sit here whether we heard about it. I'd have to follow up with that, Senator.
Senator Peters, do you have? I'm going to organize my thoughts here. Do you have some other questions?
I do. Yeah. Thank you, Mr. Chairman. Mr. Mr. Horowitz, in addition to your role as the DOG Inspector General, you also serve as the chair of the Council of Inspectors General on Integrity and Efficiency. So kind of a question. I know you've addressed this somewhat with a previous question, although I was out voting at the time. If you could speak a little bit again to the importance of the Inspector General independence, and in particular why SIGI is important to the work of Inspectors General, and what we need to do to strengthen that organization as it ties into the general theme of why independence is so important. That would be very helpful.
Absolutely. So the foundation of what we do as Inspectors General is our independence, is our ability to both report to our agency heads and Congress about what we find. We're not, very importantly, untethered from the departments we're in, but rather serve that dual purpose and that ability to report to both. And the independence is critical because we have the ability to get information like we did here, to use our own judgments without influence from the leadership of the Justice Department, the FBI, or others, but to make unbiased decisions based on our historical reviews of department activities. And that's critical. The foundation also is our ability to be transparent and our ability to produce reports like this so the public can decide for themselves what they think of our factual findings, which hopefully are 100% accurate. And I note here no one's taking issue with our factual findings, but rather inferences drawn from them. And that's critical. So we've got to be able to do that. We've got to be able to have robust dialogue, as I mentioned earlier. The fact that I may disagree or the Attorney General may disagree with me isn't a problem. In fact, it, in some respects, demonstrates the importance of our independence and our independence. Some of the things that SIGI does and the Council of Inspectors General does that's important is pull together all 73 federal IGs and bring us together for common goals, common purposes, common issues that we should have oversight of, training, but most importantly, being able to advance independence and transparency in the government, represent the taxpayers in our agencies, support the ability to get information out there to the public so that the taxpayers know where their money's going, how their money is being used, whether programs they're authorizing, in this case FISA, that are highly intrusive programs are being used wisely or are not being used wisely, and making recommendations to fix them, and then doing follow-up to make sure that's done, and being able to come up here, frankly, like I did for many years before this committee and the chairman on access to records and other issues that we were having problems with so we could do our jobs. In fact, this committee, as it's aware, this report wouldn't have been possible but for the IG Empowerment Act that you all passed, because this was one of the areas we were being hamstrung on in being able to oversee. And so that's the kind of independence we need. We need, for the reasons I mentioned earlier, testimonial subpoena authority. We can't get relevant evidence at key times, including when individuals resign on the eve of being questioned by IGs. Contractors who get sometimes tens, hundreds of millions of dollars, at some agencies billions of dollars in contracts potentially, and grant recipients who get a considerable amount of money. So there are a lot of tools we need to further our efforts. The committee has always been very supportive of our work, and I certainly appreciate it. I know as chairman and ranking members, you've both led the way on that for us.
Mr. Horowitz, as our committee states in questionnaires that we present to every nominee who comes before us, quote, protecting whistleblower confidentiality is of the utmost importance to this committee, something that, as you know, is absolutely vital for us to do our work in oversight. But why, in your words, why are whistleblowers important, and why is protecting whistleblowers of critical importance?
So precisely for the reasons you indicated, Senator, we get a significant amount of our information from individuals who are willing to blow the whistle. Some call themselves whistleblowers, some don't call themselves whistleblowers, but they're willing to come in and blow the whistle on wrongdoing and misconduct. In July, we issued a report at SIGI, the Council of IGs, it's on our website, about cases that move forward precisely because whistleblowers were willing to come in and report to us. Many of them are willing to come in and use their names, have their identities known, and aren't afraid to do it. They're incredibly courageous for doing that, but they do it. Many are afraid and don't want their names known. They want to be anonymous. Others send us information through our hotlines, and we never learn their names. Doesn't mean we can't follow up on it, but what we've got to do in those instances in particular is see if we can corroborate the information. And that's really what we're charged with doing. We want information. We want people to come in. We get, in my office, over 10,000 calls to our hotline a year. We've got to sort through them. Not all of them develop into leads. Not all of them, when we investigate them, develop into findings. But they're critically important, and that ability to come in and without fear of retaliation or the threat of retaliation is critical. And we as IGs have to do our job not only educating people so they will come in, but also making sure that if anybody's threatened with retaliation, we do our jobs to ensure that there's accountability if that occurs.
Well, I certainly get this from your testimony, but I just want to reiterate and get your response. It seems to me, based on the importance of confidentiality and the fact that you don't just act based on a confidential report, you actually have to corroborate it with actual evidence. But how you mentioned how important confidentiality is, so I suspect that identifying the identity of a whistleblower without their consent would likely to have a very significant chilling effect on whistleblowers generally. Is that an accurate statement, if you could expand?
Yeah, that's a fair statement, and in fact, Congress and the IG Act has told us we're not allowed to disclose whistleblower identities precisely because of that reason, unless there's a legal requirement that we do so, and unless we're unable through other means to protect their identity. So, look, people who come forward, it takes great courage. My first involvement in this as IG was when I walked in and Fast and Furious was ongoing. We had courageous whistleblowers from ATF come in and report that information to us. Most of those individuals put their names with the information, but people shouldn't have to do that. That doesn't mean their information is no less important that we consider, but it does mean, as you indicated, we don't act on purely anonymous, uncorroborated information. The obligation is then on us to corroborate the information and be able to move forward. But it takes great courage to come in as a whistleblower. We've got to protect identities as the law requires us to do as IGs, and we've got to make sure that if there is retaliation or threats of retaliation, that we take action.
So in September, the DOJ's Office of Legal Counsel issued an opinion that attempted to justify inappropriately withholding an intelligence community whistleblower disclosure from Congress, as I'm sure you're very aware of. What is your view of the Office of Legal Counsel's opinion in that case?
So in response to that, one of the things we did as the Council of Inspectors General is put together a letter that we sent to the Office of Legal Counsel on behalf of the IG community. It's posted on our website, that expressed our serious concern about an IG's inability in that instance to be able to present the information that he believed should go to Congress in that circumstance. And that's something that concerns all of us in the IG community. Again, the law as it's set up provided a mechanism by which an allegation could get to Congress. It required a judgment by the IG, and then it required Congress to be given that information, and then, frankly, it's up to Congress to decide what to do with that. It doesn't have to act on that. It can act on that. It makes, obviously, in all instances, its own determinations, but that's a process that Congress carefully considered and put in place in the law, and I'm of the view, and we were of the view as the IG community, that that's the way the process should have played out.
So the letter you reference from October 22nd, I have, Mr. Chairman, if I could enter that into the record without objection.
Without objection.
Thank you. And one final question. I understand that the Office of Legal Counsel has responded responded on October 25th to this letter. Are you satisfied with that response? If you could elaborate.
They ultimately responded in the way they did. We had a respectful dialogue back and forth. As I said earlier, as an IG, I didn't take this job to be in agreement all the time with everybody. We disagree, as our letter says. We stand by our views in our letter. OLC has their point of view, and I'll let readers, those are both public. And again, the public should make their own determination. That's really what we are foundationally about as IGs, is putting out information and letting the public, an educated and informed public, read them and make their own decisions.
So I gather, if I may summarize, as a professional, highly trained IG, you were not satisfied with the response. Is that?
I stand by our letter and our legal position and our views.
Thank you.
And Senator Peters, let me just talk a little bit about whistleblowers. I would share, Senator Peters, I think everybody on this committee, and your desire to afford those whistleblower protections. There's no doubt about it. It's vital. I'm shocked, quite honestly, coming from the private sector, the level of retaliation against people that come forward. But I do want to clarify the law. As Inspector Generals, you are by law barred from providing or basically blowing the confidentiality, identifying whistleblower. But the statute actually does contemplate if somebody's accused of something by a whistleblower and they're in a court of law, it actually contemplates the person being accused being able to confront his accuser, correct? The whistleblower?
It basically says by operation of law. So it'd be up to the judge to make a consideration of that. But certainly, if it was in a criminal case and you intended to rely on the witness would have to be there. What you would try and do, in police corruption cases, I've had this issue, and you have some people willing to come forward and some people not willing to come forward. And if they're not willing to come forward, you've got to figure out how that information, if possible, and it not always is, if possible, can be translated into the federal rules of evidence allowing that information in a courtroom.
But again, there's not absolute statutory protection in terms of whistleblowers' confidentiality.
No, the statute, the IG Act says we have an obligation to keep it unless the law requires us to do otherwise.
I just want to kind of tie up a few loose ends here. I've got a lot of questions, which we will submit as questions for the record, and we'd appreciate you to be responsive on that. Real quick, going back to the Bruce Orr activity in terms of being a conduit between Christopher Steele and the FBI. Peter Strzok, in your report, has handwritten notes, which pretty well demonstrate he knew about Orr's activity, and yet in his interview with the Inspector General team, he denied that he was aware of what Orr was doing. Are you buying his denial?
So I'd have to go back and frankly refresh my recollection on the notes versus what he told us. I'd want to just double check on the breadth of what he knew, because Bruce Orr having 13 meetings, he clearly knew, for example, about the Manafort-related meetings because he was at some of the Manafort-related meetings. So I just would need to
we'll put that in questions for the record. I do want to talk a little bit about monitoring or surveilling the, what is the euphemism? Consensual monitoring. In other words, you're wiring somebody to surreptitiously record someone associated with the Trump campaign versus the Trump campaign. I think it's a difference without a distinction, but there's a distinction because there's a difference in terms of what authority, what approvals the FBI would have to get, correct?
Correct. That's the reason for the distinction, but I agree with you. There's varying degrees here of what occurred.
So they were trying to be pretty scrupulous about saying, we're not surveilling the campaign. We're just surveilling people associated with the campaign.
So what ended up happening here is, as you said, and we'll try and what they did was they took individuals, informants that were signed up informants for the FBI, wired them up so they could be recording conversations they had without the person they were speaking with knowing that they were being recorded. That's, in essence, what a consensual monitoring is.
Sounds really
One
close.
party's consent.
It really sounds really close, like you're monitoring the campaign. But again, just lay that aside. That's my own personal opinion. Did you ever determine why the FBI changed its opinion? I think early on when they interviewed, and again, this was not exactly done above board, but they interviewed Michael Flynn. At that point in time, I think the agent did not feel that Michael Flynn was, dishonest with him. Somehow that changed. Do you have any idea why that opinion changed?
I don't know. I've heard that, but we actually have no insight into what happened there on that case specifically.
Quick follow-up on Senator Paul's line of questioning, and we spoke about this a little bit earlier too. there really are a lot of controls in current law that, had they been followed, the Woods procedure, I mean, other requirements that the FBI, and everybody knows this, they have to be scrupulously accurate. So there's plenty of layers of control over this FISA application, correct?
There are a lot of layers of control.
And I realize your limitation, you can't really recommend legislation. You have to kind of stay within your lane of the Justice Department, but do you really think another layer of controls is going to fix this problem? Because this was caused by people circumventing.
Right. There are certainly some controls that could, additional controls that could help. For example, on some of the informant activity and others. With regard to the FISA, I agree. I think there's, and this at the hearing last week and this week, real questions about does there need to be legislative activity here? And of course, there's also now the FISA court has put out its order, and they're going to have some involvement, obviously, in a significant way in that decision-making as well. That's well beyond the executive branch figuring out what it should be.
My own personal opinion, for somebody who has definitely supported the FISA court, largely because we were told, well, show us where their abuse has been. That these applications are approved at such a high level because it is so rigorous. It is so scrupulously accurate. Now, that's been completely blown. I think the FISA court is in jeopardy, personally. And I view that as a very serious issue in terms of our national security. So I think it was James Langford talking about that. So I agree with his concerns. Final two questions really speak to the limitations that you have in terms of conducting an investigation like this. So real quick, who couldn't you investigate? I mean, or what couldn't you investigate? Who couldn't you talk to? That if you'd been able to, you would have been able to tell a fuller story here? Because there's still a bigger story to be told.
So our review, as we made clear here, is about the Justice Department and the FBI's handling of the opening of the Crossfire Hurricane investigation and the Carter Page-related FISAs, along with the FBI's activities on their confidential human sources and surveillance that the FBI did. We did not go and look at or try to assess allegations about what the State Department
So you would kind of like to have known that, right?
Well,
But you can't. You couldn't do it.
We certainly wanted to know from the State Department side, which is why we went to Mr. Weiner, what Bruce Orr and Mr. Steele's activities were with them. What we weren't trying to figure out is separately what the State Department might have been doing on their own or their own interest, if they had any. I don't know, as I sit here today, if they have any. People have asked questions about what did other intelligence agencies know. If that information was sitting in the FBI's files, we had access to it. If it's something they did separate and apart from the FBI, that was beyond the scope of this review.
But you'd kind of like to know how George Papadopoulos met all these individuals that just happen to be connected in different ways.
I think you'd want to, it would be interesting to know a lot of pieces of information that are strands here. I don't necessarily believe it would have, well, based on the access we had at the FBI and the information we had at the FBI, in terms of the FBI, what affected the FBI's decisions, I have no reason to think there's something else out there that we didn't see.
Okay.
Right.
This is very similar, but what other big questions are outstanding?
Well, it depends. At the FBI, I'm not sure what other questions are out there other than what I mentioned earlier, which is how did all of these failures in the FISA process that's layered with all of these controls happen and why? And I know that's a big question for people to know an answer to, and I understand why. But at this stage, that I think we didn't get good explanations about, and that was something we frankly would have liked to have gotten good explanations about.
Well, again, I want to thank you and your team for really an extraordinarily good piece of work here. Understand the limited nature of the scope. We will be providing additional questions for the record. We've obviously been looking for this to guide our actions. And one of the reasons I've asked those last two questions is that would also help guide our future oversight as well. You are obviously steeped in this. You have the details. So I would just ask your entire team, who else would you want to have interviewed that you didn't have access to? What other questions do you think remain? And I'll just kind of throw that as an open-ended question for our questions for the record.
Okay.
But again, I want to thank you for your integrity, for all your hard work and efforts. This is unbelievably important, what you've revealed, and we've got a lot of work ahead of us. Yep. Senator Peters, you want it? Okay. With that, the hearing record will remain open for 15 days until January 2nd at 5 p.m. for submission of statements and questions for the record. This hearing is adjourned.